everybody, to another installment of Comp and Coffee. I'm Sean Lavana.
And I'm Katie Rosa.
And I'm Bill Coleman.
And thanks, everybody, for joining us today. Today on the podcast, we have Steve Weatherhead. Steve is a lawyer. He counsels clients on federal and state employment issues. And we brought him on today to talk about the new pay equity laws that are going to affect in Massachusetts. Specifically, the conversation broadens out. We just recorded this. It broadens out a little bit more than that to cover it. But Steve's very well versed in this. We were excited to talk to him today. He helped us out on a roundtable out here before. And so we were bringing some of the findings from that back and some of the things that we heard. We'll put Steve's contact information in the show notes if you have any questions for him. Otherwise, let's launch into it. So there's a ton going on right now with the Equal Pay Act here in Massachusetts, and I know there's others similar around the country, but we thought, due to the location, the timeliness of all this, we'd focus on the Massachusetts part today, particularly because it was, I believe, the first that was passed and just not the first implemented. We held a roundtable on this a while ago. If anybody wants a quick recap of that, go back and listen to episodes 2 and 3. But there's a bunch of stuff that came up that it's becoming much more timely now since this is going to affect on July 1st in Massachusetts that I'm curious to get your take on.
I have never been asked to opine on a Mass Equal Pay Act matter. I've never litigated it or defended a matter. It was more or less a dormant law. Where it would come up was more in the discrimination context, where typically a female would bring a gender discrimination claim saying, I was paid unequally, as well as other areas that were discriminatory. So it came up more that way. But yeah, there is a new push, partly being driven by social media, being driven by the Me Too movement and other things, to really bring both transparency to pay and actually change some of the rules. The former Massachusetts statute, one of the reasons why it was somewhat dormant is that it defined comparable work very, very narrowly. And so it was very uncommon to have a violation or define a violation. And that was one of the concerns by the legislature when they were enacting this new law. They've now sort of broadened the definition, provided other sort of guidance. And so now this really is becoming the new world order. Again, Massachusetts is leading the way. I know we're focusing on that today, but just as a quick aside, since Massachusetts has passed its law, in terms of the salary history component, as you know, the Massachusetts law has two primary components. You cannot inquire of job candidates about their salary history. That's part one. The other part is you can't have pay differentials, gender pay differentials for comparable work. With respect to salary history, that is picking up steam. Delaware's law already went into effect earlier this year. California and Oregon also have similar salary history laws. Unlike other employment areas, this is an area where cities and localities are getting into the game. And so you have New York City and both Albany and Westchester counties in New York also prohibiting employers within their boundaries from asking about salary history. One interesting thing is just last week, a federal judge in Philadelphia invalidated the city of Philadelphia's salary history ban on the basis of the First Amendment. It said that by prohibiting employers from asking about candidates' prior salaries, it violated the First Amendment of the Constitution. The court went on to say, though, however, that regardless, it upheld that part of the ordinance that said employers cannot use that information to set the salaries. So you have a weird situation in Philadelphia where basically you can get the information, but then you can't do anything with it. It's interesting whether other jurisdictions or other challenges will be made on constitutional or other grounds as well. In terms of the equal pay piece of it, more than half of the states already have equal pay laws, much like Massachusetts, but most of them are evaluating those and, like Massachusetts, making enhancements and making amendments. By way of example, both Oregon and New Jersey have enhancements to their existing equal pay laws going into effect later this year.
So, Steve, this is Bill. You said something interesting about the definition of comparable work and how it's been expanded in the new law. How far have they expanded it, and how do you, as an employer, know what is comparable? Is a financial analyst comparable to a marketing analyst comparable to a compensation analyst?
Yeah, it's a great question, Bill, and I think one of the central concerns of the business community with this act, because there's still a lot that's left to be sort of determined, and a lot of unanswered questions, which is common when you have any new legislation. Under the old act, the one that was passed in 1946, comparable work was defined as two jobs having similar duties and requiring comparable skill, effort, responsibility, and working conditions. The new law, which again goes into effect on July 1, removes the similar duties test, but retains the required skill, effort, responsibility, and working conditions. So what that means now is two people could be doing completely different things. You could have someone in the finance department, for example, doing comparable work to someone in your marketing department, for example. But it's not quite as severe as that may sound, at least initially. So when you look at the regulations, they actually provide some flesh around those terms: skill, effort, and responsibility. First of all, effort is generally related to mental or physical exertion, and similar working conditions is defined as whether the work environment is hazardous, or you work outside or inside. So with that, for most, at least white-collar environments, the effort and similar working conditions components will really be irrelevant. So we're really focusing on the skill and responsibility. And I think your question, Bill, really implicates the skill piece of that. Skill includes the experience, training, and education and ability required to perform the job. So to use your example, an IT analyst likely requires certain technical or computer skills and maybe even certain certifications. Whereas a comp analyst may have similar job, similar level in the organization, similar educational requirements, but requires different skills like a World at Work certification or something else, and may not have to have the technical skills. So in that case, where everything else is equal, they would not be comparable because they don't have the same skill. And remember, it has to be skill, effort, and responsibility. It has to be all three, not just any one of them. So it still leaves a lot of open questions, Bill, no question, because you're no longer comparing similar duties. But that skill piece is where I think we're really where that's gonna come into play.
I mean, that's good, because in our seminar that we had a few weeks ago, that was a big issue, and people were worried that all things that were similar loosely would be treated as comparable work, and that for example, the marketing and the IT analysts would be given, would have to be treated the same, and basically everybody at the same title level would end up having to be at the same pay. It's good to hear that that's not the way it's currently being thought or currently being interpreted.
Right, and let me give you two examples that they actually use in the guidance itself, the recent guidance that came out, which provides a little flavor for this. A bookkeeping job, and I'm just reading this verbatim, a bookkeeping job usually requires accounting skills but does not necessarily require customer service experience. Therefore, a bookkeeping job may not be comparable to a job that relies heavily on customer service skills, such as the job of an account manager. And here's a different example. In an elementary school setting, janitorial and food service jobs generally do not require previous experience in the field or specialized training, and therefore may require comparable skills, even though the substance of the two jobs is different. So while I don't want to turn this into a white-collar, blue-collar analysis, I would think in certainly most office-type environments, there's enough distinction and difference between, for example, finance, sales, marketing, engineering, whatever it might be, product, that you should be okay. Although, there's some on the margins, there still might be some issues. But yeah, so it's not quite as draconian as one thought when reading the statute literally. So the guidelines did sort of provide some relief there.
It's good to hear.
And let me ask, what about equal pay? Because that was one of the other things. So we now know, we're really starting to get transparency on what's comparable work. What counts as equal pay for when we're looking at, the totality of it? So obviously just salary base or wage base is always part of it. But what about bonuses, commissions, other things that you can include in that?
Sure. The regulations sort of have a two-part approach to this. First of all, is they look for part one is they look solely at base salaries or wage rates, and those have to be comparable. Period. Before you look at anything else. So you can't have people making $4 an hour, 40 cents more an hour than other people who are deemed to be in a comparable job. But in terms, so that's part one. That has to be. There can't be a disparity there. Secondly, there cannot be a disparity if you look at the entire universe of wages, which includes not only base pay and salary, but bonuses, commissions, production incentives, profit sharing, etc., expense accounts, car and gas allowance, all that stuff. So you couldn't, for example, say we're going to reimburse the men 51 cents per mile when they travel, and reimburse the women 48 cents per mile. Where it gets really tricky is it also includes what employers typically characterize as benefits, including paid time off, sick or holiday or vacation, retirement plans, insurance plans, and this catch-all called other benefits. So obviously you need to look much broader than just straight wages and salary. One question that has come up and that I don't have a good answer to is, what about equity? I know many employers don't offer stock options at least as much as they used to, but what if they do as part of the condition of employment? Is that considered a wage? Does that fall within the other benefits? I've received that question several times from clients. I don't have a good response, and I think that's one of the areas that's going to be fleshed out in litigation at some point.
So if I heard you correctly, though, base pay has to be comparable regardless of the other stuff, but base plus everything else, total comp, if you will, has to be comparable also. Right.
You need to basically pass the two different tests. So in other words, you couldn't, let's assume you're paying your females 50% less base salaries for comparable work, but you're making it up to them in a bonus at the end of the year. That won't work
Right.
Because you need to have now let's assume the salaries are equal and there's disparities and maybe a bonus or a commission structure. Within that group, you can sort of enhance benefits in one area to make up for a deficient area somewhere else, if that makes sense.
So using your example of the men getting reimbursed 51 cents a mile and women 48 cents a mile, you could have perhaps a higher healthcare benefit for women and say that it evens out.
Mm-hmm. But what you couldn't do in that instance is again, you can't use those other components to make up a deficiency in the salary.
Right. Got it. Curious. Do you in the context of bonuses or incentives, are you seeing or hearing anything that about the way companies are thinking about changing their pay for performance and ramping it up, or certainly what we're seeing is companies thinking about putting more rigor around their incentive plans, making sure that they are defensible, so that if one group ends up getting paid more through a bonus, it's not going to be perceived to be gender based.
I think you're right, Bill. One of the as you know, the law sets forth an exclusive list. It's not a suggested list. It's exclusive, where there's 5 or 6 areas which would justify a pay disparity, and one is a bona fide merit system, and that's defined in the regulations as a system that provides for variations in pay based upon performance as measured through legitimate job-related criteria. Now, I think a lot of employers sort of do this as part of their sort of annual review process, maybe not as formal or as robust as they need to, but certainly, when somebody gets ranked low on their reviews, typically that's a factor considered whether they get a raise, for example. So what I think you're going to see, though, is because of this potential exception, you're going to see employers really start to formalize those processes more, make it more justifiable, which would include some of your more typical pay for performance type initiatives. But I certainly think it's going to behoove employers to really get more definition around their compensation structure.
Yeah, that makes sense. We're starting to hear it, and I'm sure that others are going to start to hear it more as time goes on.
Right. I will say pay for performance, at least in my world, is one of those phrases that I think gets no one really sure what people use it differently.
Right.
And I'm not sure how you use it in your context, Bill, but again, I think generally that's kind of what the law is asking you to do if you think about it. You need to make sure it fits the contours, but basically that's what the law in effect is asking you to do is, one, sort of make up for the historical wage disparities, and then two, obviously performance becomes a key aspect.
How long until the first company comes along with weekly pay for performance bonuses? Mapping.
Now that you mentioned
it won't take long for people to figure out the loopholes.
What was that, Sean?
I said, now that you mentioned it, I think it's only going to be a couple of weeks. July 4th? I don't know.
Yeah.
And,
right.
So, Steve, Bill mentioned that a few weeks back we held a roundtable here in Massachusetts to talk about this topic with some comp professionals. And one thing we heard there was that employers are worried that they'll have that, the classic stray manager who continues to ask, what do you make to candidates during the hiring process? But under the law that goes in effect here in Mass on July 1, this is going to be illegal. So what guidance would you give to employers with this concern?
Yeah, it's a good one, and you put your finger on one piece of it. There is a little bit of misunderstanding out there that you can't ask about salary information ever, and that's just not the case. It's only to candidates and only up until the point where they've been given a formal offer of employment with a compensation, a formal offer of employment and compensation. At that point, or once somebody's already hired, you can certainly ask the information all you want. You may not get it, but there's no liability for asking for it.
Okay.
The only answer I really have is, much like everything else, is just good training. There's a lot of other areas in interviewing where managers could harm the company. For example, some sort of discriminatory questions, such as how old are you, or are you going to have children? Are you going to require maternity leave because that's a concern of mine? Things like that. I'm actually more concerned about questions like that. But this is just another piece of the training for managers that they just got to start training themselves not to ask for this information. Recruiters as well. There is a exception, as you know, that says if someone volunteers the information, then it's okay, or there's no liability. As a defense lawyer, that concerns me because once a lawsuit makes its way through the courts and it's 4 years later, and there's nothing documented, who's going to remember? The only memory is going to be, there was a discussion. It's going to be very unclear as to who brought it up first, whether it was coerced, and it becomes the classic, she said. That concerns me. So I've advising employers to don't take the bait necessarily, even if somebody volunteers the information. Because at the end of the day, even if you have the information under the regulations, you can't do anything with it. You're not allowed to use it as a factor. So it doesn't, whether you get it or not. But I guess it's another way of saying there's no upside to even asking for it because you can't do anything with it. And there's only downside. Rogue supervisors are a constant problem, particularly with larger decentralized employers. But short of training and just active performance management, I don't really have any other grand ideas.
Yeah, I think that's the key message, right? Is that it doesn't matter how you acquire it; you can't use it anyway, so why bother?
Right, and on the salary history piece, as you know, in the pay equity piece, there is an affirmative defense, and if you're doing a self-evaluation, you can avoid liability. There is no such affirmative defense for the salary history question. If you ask it, you're liable. Now, if you hire the person, likely there's no damages. It's a technical violation, but there may not be any consequences for it. But if the person doesn't get hired and you've asked that question, you can pretty much rest assured they're going to complain about
I
it.
have to me, an interesting question. You just talked about affirmative defense, and earlier you were talking about the in pay for performance, about the exhaustive list of things that have to be included. When it comes to actual how much people are paid at, let's just say, the exact same job. Say I'm an employer, I have 101. I know it's a silly number. 101 customer service reps. And I have 50 women getting paid $50,000 a year and 50 men getting paid $50,000 a year, and one woman out of the 101 that gets $60,000. Do I have a gender pay equity problem because I have one person who's getting paid $60,000 among a pool of people that are all at exactly the same the same rate, and then am I on the hook to raise everyone to 60 and pay $1 million for some, let's just say, legacy issue or whatever that had that one woman at 60?
It's a very good question, Bill, and I don't think it goes. You're right to bring it up in the context of the affirmative defense, because I think that's where it plays in. So first of all, the regs make very clear that intent doesn't matter here, and you kind of touched on that a little bit. You said, or at least I think you said that she's being paid more, but it's not a gender issue. Well, right. Unless you can point to one of those 5 or 6 exceptions, then by definition it is a gender issue, right? And whether you intended to or not, or that wasn't the purpose or the goal, is irrelevant. And the fact that you might have some other women who are still being paid less than those men, the point is it's the men in that situation who really have the claim.
Right.
And again, there actually is still some misunderstanding out there that people think only women can bring a claim under this act. That is absolutely not true. If women are paid more than men for comparable work, then it's still gender inequity. That's not the typical situation, but that could still happen. So what happens in this case? Oh, and there's another section of the law, Bill, as you know, that says market forces is not one of the legitimate criterion that you can rely on, right?
Right.
So the fact that you hired people 5 years ago when the market was hot for software engineers and you had to pay a premium doesn't give you an excuse to now, not bring everybody else up. Now, you don't have to just, in one fell swoop raise everybody, okay? If you've done as you know, under the affirmative defense, if you've done a self-evaluation within 3 years prior to being sued or being looked into, then so long as you can show that you're making reasonable progress towards, you've identified it's an issue and you're making progress towards rectifying it, then you will not be liable. It's an absolute affirmative defense. So, for example, in this situation, we're slowly bringing everybody up to 60 through normal pay adjustments. We're freezing the person at 60, everybody at 50. We're going to slowly raise up over the next 2 years. That would work. That would be an affirmative. You would not be liable in that situation. So it plays into that. Now, there's another regulation that says you can't reduce somebody's salary
right.
in order to become compliant. So the answer here would not be to reduce the woman making 60 down to 50. So the point is, there are going to be legacy type situations like that. Someone negotiated better. Someone, was a friend of a friend. And, there's several different legitimate factors, at least previously legitimate
right.
factors that came into play. So that doesn't necessarily go away, but they're giving you time to fix it. So, but ultimately, you're going to have to, bring people up to speed or up to par.
Or, and having 30 some odd years of HR consulting experience, somehow I feel that woman is most often going to get promoted or transferred to another job.
Well,
solution?
I'm not, the law of unintended consequences, right?
Right.
I fear, I don't think any of my clients do this, but, one never knows. But does that give you an incentive to terminate that person making 60,000 for some other legitimate reason, right? And is that illegitimate? So you're trying to level it. The answer is I don't know. I mean,
I wish.
Or is it going to depress wages?
Job within the company, like make it.
Or you do that too, right? Right. I personally think it might have the effect of depressing wages, and I think it might make people reluctant to hire women. I fear that that's one of the consequences here, both of which are improper. Don't get me wrong, but that's that's what happens sometimes with laws like this.
Right. Certainly, if you have a group of people at the same job that all happen to be men or all happen to be women, companies are going to be at least have to think about that.
That's right. Let's say, for example, you have a company right now with 10, 15 salespeople, all making sort of various base salaries, right? Which is fine because they're all one gender, so there's no issue. Then but if you brought a woman on, there's some legacy people who you would never pay her as much as you're paying the top person because he's a legacy for some reason. Yeah, I think employers would go, oh, maybe we shouldn't hire that person. Because of it. Now again, that's illegal. Proving it's another story. So I think there is some of that going on. Yeah.
And it's completely the wrong reaction. But as you said, law of unintended consequences.
Right.
And maybe since you brought it up, for the listeners out there, what are the affirmative defenses? Could you just list them off?
Well, it's one affirmative defense, but it's sort of multi-part. Basically, if when you get, I'm just going to pull up the regulation so I don't misspeak here. Okay. If an employer conducts a good faith, reasonable self-evaluation, I won't get into the regulations define every one of those terms. I won't get into that at this juncture. But if you've done a good faith, reasonable self-evaluation within the prior 3 years, and you have not had a claim filed against you prior, then you will, if you have a lawsuit, you will be, if you can show that the evaluation was reasonable in detail and scope, meaning you can't just sort of do a 5-minute analysis, right? You want to do a deeper dive and maybe some statistical regression analyses, maybe not necessary. And you're showing reasonable progress towards eliminating any unlawful gender-based wage differentials. If you do that, it's an absolute complete defense. So then there's a second part. If you've done something within the last 3 years, but your self-evaluation was not determined to be in reasonable in detail and scope, you don't have a complete defense, but you can avoid the liquidated damage piece of it. You only pay 1x damages as opposed to 2x damages. So, without getting more into the weeds, the real point is you've got to do a self-evaluation. And the sooner I think employers do that, the better. And then they're protected sort of for the next 3 years, so long as it's done, properly. Generally, I've been asked to do some pay equity analyses. Generally, lawyers don't do that. At least this lawyer doesn't. It requires some software, some statistical ability.
Hey, Steve, let me ask you in that same line of thought. One of the things we heard at the first roundtable was that people who are doing that analysis there was actually a really good discussion of should they do it under privilege of counsel. And it seemed that the group wound up thinking that, yes, they should, because if anything's exposed, they have the ability to fix it then before, they have to disclose it. So what's your take on that?
Yeah, I'm always reluctant to give a one-size-fits-all answer because that's sort of almost an individual case-by-case situation. That said, as a lawyer, I'm always reluctant to advise any client to create discoverable information that could create some financial exposure, unless it's privileged. I mean, that's just that would be bad advice. That said, though, in order to take advantage of the affirmative defense, or if you want to take advantage of it, you're going to have to waive the privilege. You're going to have to show what you did, you have to prove that it was reasonable in detail and scope, that it was done in good faith. So at the end of the day, while you might be able to keep it privileged for a period of time, for it to have any value, you're frankly going to have to waive it. There is a part in the regulations that came out. I can't remember if this was part of the statute or not. The good news is that these self-evaluations cannot be used as evidence in court or at the MCAD under certain circumstances. So even if you're creating this adverse information, it may not even have any evidentiary value for an employee. I'm not going to get into the details of which circumstances it applies to, but generally speaking, the point is they're trying to encourage people to do this, and they're taking away some of those obstacles or hindrances to doing it so that they will do it. The other thing, and it's not a legal issue, it's more of a sort of a cultural issue, is that one of the whole goals of this statute in and of itself is pay transparency. Because as you know, one of the other provisions is that employers cannot prohibit employees from discussing their wages with each other. So, given that, that's the goal of the act. Given that the Me Too movement, which is a little bit different but related, and sort of the transparency issues surrounding that. I mean, the other thing an employer needs to consider, I think, is what sort of backlash it might experience either internally among its workforce or externally with clients or public relations, if you're trying to cloak this thing in attorney-client privilege. It kind of defeats the whole purpose, I think. So, again, that's not necessarily a legal consideration, but I think an important one as well. The bottom line is, Sean, I think every case would be different, and it's something that I think you'd have to explore with your counsel to see whether it makes sense in your particular situation.
Yeah, appreciate that. Makes sense.
So, Steve, in your experience with similar kinds of law changes, how long does it take for the system to work out all these kinks and unintended consequences and settle on a decent set of rules or guidelines? And in this case, how long do you think that would take?
Yeah, it's a really good question. And I'm going to answer it. So there's really two parts. So it's a two-part answer. Because employees who are aggrieved by pay equity issues have two options. They can go directly into court themselves, bring out what's called a private right of action, hire a lawyer, and sue their employer. And they have to do that within 3 years of the discriminatory act. So if that's the case, that can happen on July 2, July 1 even. And there's nothing to prevent that. So employers can go straight to the courts, and the courts are just going to look at the law and interpret it as they see fit. The other option employees have is to file a claim with the Attorney General, who will investigate it and then decide whether to proceed on the employee's behalf. In that situation, if history is any guide, the Attorney General generally gives a few months of sort of leeway or a grace period. If it's a very egregious violation, or you just didn't care about the law or didn't even try to change anything, you're probably not going to get a break. But if you've at least tried and you're on the way, the Attorney General will give you a little bit of slack. That'll only last a few months, though. The example is from a few years ago with the earned paid sick leave law that we referenced earlier. Again, very controversial when it came out. The business community didn't have a lot of time to prepare for it. There was a brief period where the AG was working with employers and more in the nature of being advisors and guiding, and then that stopped, and then the audits started happening within about 6 months. So that's what I expect to happen. I think this law has much more legs than the earned sick leave law. I think the AG is going to will do audits almost immediately. I think there is a backlog of cases waiting to be filed. I really do. I think the plaintiff's bar has had plenty of time to prepare for this, and that there are a number of complaints that will be filed on July 1, 2, 3, 4. Unfortunately, it just is. So that's, and in terms of all these unanswered questions, Kate, like for example, equity, does wage include equity? That those will just have to work their way through the courts, which often takes, literally years and years and years. Unless the legislature steps in and amends the law in the interim, which is unlikely to happen, at least in the short term.
So similarly, can you talk a little bit about how individual state laws spread across the country, and then how the federal government adopts a national version? Like, how long does that take, and do you see that happening in this case?
Yeah, well, again, as I said earlier, over half the states already have equal pay laws. Many of which are dormant, like Massachusetts' former one. Oregon and New Jersey are in the process of enhancing their laws. There's a handful of states that have no pay equity laws. Not surprisingly, they tend to be red states. Utah comes to mind, Texas comes to mind, Tennessee comes to mind. So then you have the federal law, and again, the federal law is already there, and it's been around since the Kennedy administration. It's a very, very, very narrow. It's not used that much. Most aggrieved employees pursue their remedies in state court because they get it's a better forum. It's easier to prove your case, and the penalties are better. I don't expect the federal government to wade in here and amend or strengthen the federal act. Under the Trump administration, very little is happening by way of employment legislation, and they seem perfectly content to let the states sort of pick up the slack here. So I think you're really going to see and unfortunately for multi-state employers, you're going to see a patchwork of laws that don't necessarily talk to each other, and they may conflict with each other. For example, in Delaware or California versus Massachusetts. Most Massachusetts employers of any size have an office in California if they're in the technology space. Those are the two toughest jurisdictions, and you're going to have to make sure you comply with both.
Yeah, so is the answer there, just to be safe, to go with a more stringent set that applies?
Yeah, good point, Sean. Whenever there is two different laws that apply, a state and federal law, you have to comply with the one that provides the most generous benefit. And that's just a matter of that's the nature of our federalist constitutional system.
Well, and then also if you have two competing I shouldn't say competing. If you have two similar state laws, one's a little bit tougher. For example, you would want to go with, if California is tougher than Massachusetts, you have offices in both locations. You want to go with the California set probably just to be safe.
Or you're right. You have a couple options here. You can have each office sort of treated separately, right? In our California team, we're gonna comply with California. Our Massachusetts team, we're gonna comply with Massachusetts. Or what most employers do, because that's really not scalable, right? Is you pick the one that has the most stringent requirements, and as long as you follow that, you're effectively complying with everything. It's unclear to me how employers are gonna respond to this one. The problem with that approach, a different approach based on jurisdiction, is that employees can be transferred either permanently or temporarily. What if someone's working remotely from their home in Illinois, but they're reporting into Massachusetts? Does the Massachusetts law apply? Those are a lot of other questions that multi-state employers are going to have to answer.
And so just to wrap up today then, if you are an employer, let's talk particularly in Massachusetts, and you haven't done anything yet, should you, or should you wait for this stuff to shake out? And if you should, where do you start and when? Yeah,
I think there's no time like the present to at least start building into your process or changing your process to stop asking the salary history questions. Make sure your recruiters and anybody that does interviewing is aware of that. Make sure your forms and your applications reflect that. That's low-hanging fruit that can and should be done promptly. The bigger question is, of course, whether to do a self-evaluation. I think certainly doing a high-level spot check, even if you did it under the historical rules, right, similar job duties, at least do that now. And if there's something wrong there, that's going to be a problem. That's going to be a violation. There is no argument there. So, at the very least, fix that now, and then focus on some of the other stuff as this progresses. The problem is, once you file the way the affirmative defense works, once somebody files a lawsuit, if you do any self-evaluation that you do then is not relevant. You can't take advantage of the affirmative defense. So if that's true, and if it's true that my prediction comes true that there's this pent-up backlog, and you're going to see a lot of cases filed the first week in July, employers have a very short window between now and July to start that self-evaluation.
Yeah, no, that's a great point. And, we've taken a lot of your time today. Greatly appreciate everything that you've offered. We'll put your contact information in the show notes if anybody wants to follow up with you on specific questions or get more information on this.
Thank you.
All right. Well, we thank Steve for coming on today. It was another great show. Learned a ton. If you want to contact him again, his contact information is in the show notes. If you want to contact us,
you can find us on social media. Hit us up on Twitter @PayFactors. Also, if you're interested in hearing more about this topic and others related to comp, make sure that you register for CompCon coming to Boston September 17th and 18th. That's CompCon, CompCon, and you can register at compcon.com using code COFFEE to get your ticket for $99.
And we will be covering this topic in the sense of Lily Ledbetter, the person behind a lot of these efforts, the more modern efforts behind this, will be presenting at CompCon and speaking there. So check her out, check out the rest of the agenda, and sign up. We can't wait to have it. All right. Thanks, everybody, for your time this week. We'll see you at the next one.
Over and out.
Thanks.